of the Social Health Insurance Fund Act 2023 constitutes a violation of Articles 201, 205, 2061 of the Constitution. The petitioner contends that the Section 38 of the Act, as currently enacted and significantly amended from the original bill, violates the principles of public finance as enunciated in Article 201 of the Constitution. These guiding principles of public finance encompass openness, accountability, public participation in financial matters, the promotion of an equitable society, the prudent and responsible use of public funds, and clear, responsible financial management and fiscal reporting. The petitioner accuses the National Assembly and Senate of breaching these tenets, first by failing to consult the Commission on Revenue Allocation, that is the Commission, before enacting the legislation as required under Article 205 of the Constitution. The Attorney General, the CS, the NA, and the Senate defended the omission of the initial Section 38 on the basis of Article 206, Sub-Article 1, maintaining that the Social Health Insurance Fund was established under the Act for that purpose and that there is nothing unconstitutional with Section 38, since the Constitution under Article 2061 allows the same. Article 2061 provides as follows, quote, quote, there is established the consolidated fund into which shall be paid all money raised or received by or on behalf of the national government, except money that A is reasonably excluded from the fund by an act of parliament and payable into another public fund established for a specific purpose, quote, quote. We do not agree with the petitioner on the submission that the three funds established are ambiguous. We note that the Social Health Insurance Fund, the Primary Health Fund, and Emergency Care Insurance Fund are all established under Sections 25, 20, and 28 of the Act, respectively. Contrary to the view expressed by the petitioner, by dint of Section 5 of the Act, it is a function of the authority to manage the funds and to develop guidelines for the operations and implementation of the funds established under the Act. We, however, note that the operationalization of the specific sections is yet to be effected by way of regulations. We agree that there is reason for apprehension as expressed by the petitioner. This is so because the current section was introduced ignoring a key principle under Article 201A, which emphasizes on the need for openness, accountability, and public participation in financial matters. Further, the question that lingers in our minds is, why was the new Section 38 introduced without the benefit of public participation? The provisions of Article 201 of the Constitution must be understood and interpreted against a histography of Kenyan society. The drafters of the Constitution were certainly intent in representing a departure from a past where public matters were preserved of closed dialogue in opaque rooms only rubber-stamped by Parliament. Section 38, in our view, therefore, fails the test under Article 201A of the Constitution and is therefore unconstitutional. We should point out here that we appreciate the effort of the CS in attempting to realize the socio-economic rights provided under Article 43. The effort is commendable. The research and the industry shown in coming up with the pieces of legislation is also commendable. The objectives and purpose of the impugned legislations were to have a progressive, transformative, and a huge impact in the realization of universal health care for this country. However, the haste with which they were enacted infringed on the national values and principles of the Constitution. Inasmuch as we appreciate the noble intention, we cannot disregard the clear constitutional tenets which binds us. Article 20 requires us to promote and protect the values that underlie an open and democratic society and the spirit, purpose, and objects of the Bill of Rights. Being cognizant of the importance of the impugned laws and the input that has already gone into the enactments, and recognizing the purport of the enactments as far as the realization of the rights under Article 43 of the Constitution, we are prepared to give Parliament an opportunity to redeem itself and save the laws. The breaches that tainted the laws are redeemable within our findings and can be corrected. Let Parliament undertake sensitization, adequate, reasonable, sufficient, and inclusive public participation in accordance with the Constitution before enacting the said acts and amend the unconstitutional provisions in terms of this judgment. B. Compliance with the A above be undertaken within 120 days of the date of this judgment. C. Within that period, the acts shall remain suspended. D. In default of A and B above, on the 10th day of November 2024, the following relief shall take effect forthwith. 1. A declaration is hereby issued that the entire Social Health Insurance Fund Act 2023, the entire Digital Health Act 2023, and the entire Primary Health Act 2023 are all unconstitutional for the reasons set out in this judgment and therefore invalid, null, and void. Since this was a public interest litigation, we order each party to bear own costs.